Welcome to The Other Side, Mississippi Today's political podcast. The Other Side lets you hear directly from the most connected players and observers across the spectrum of politics in Mississippi. From breaking news to political strategy to interviews with candidates and elected officials, we'll bring you facts, perspectives, and context that helps you cut through the noise and understand all sides of the story.
I'm Bobby Harrison, political reporter of Mississippi Today, and I'm here with my colleague, as we're often together these days, Taylor Vance. How you doing?
I'm good, Bobby. Glad to be here.
Good. And Taylor, we have with us today somebody who is often seen in the media in Mississippi, not because he's searching out, just because he's dealing with big cases. Rob McDuff, Jackson attorney. Rob, how are you doing?
I'm fine, Bobby. Hi, Taylor. Thank you all for having me.
Yeah, Rob has been involved in so many big cases. He's affiliated with the Mississippi Center for Justice, and we're lucky to have him today to talk about a couple of issues he's been involved with in recent. One of them just over the past couple of weeks, and we'll start with that one. There's a trial going on dealing with the districts of the Mississippi legislature, trying to redraw some of those districts. There's been about a 2-week trial that just concluded. Tell us about that case.
Yeah, it was an 8-day trial that concluded on Wednesday. It is a case in which Mississippi Center for Justice and several partners, including the ACLU, the Lawyers Committee for Civil Rights Under Law, the Morgan Lewis Law Firm, and Attorney Carol Rhodes are representing the Mississippi NAACP and Black voters from around the state in challenging the redistricting plan that the legislature drew for itself in 2022. And we are alleging that the legislature failed to create majority Black districts that could and should have been created under the Voting Rights Act, and that this existing plan underrepresents and dilutes the strength of the vote of Black voters in Mississippi.
And yeah, this case is a little different than what I kind of think of when I think of redistricting cases, because y'all are not trying to have the entire state redrawn. If all 52 Senate districts and all 122 House districts, y'all are dealing with. Explain that to us.
Yeah, we are arguing, and we put on evidence to the fact that the state could and should have, under the law, drawn 4 additional majority Black Senate districts and 3 additional majority Black House districts in certain areas of the state. And so to correct the problem, the districts in those areas would have to be redrawn. It wouldn't necessarily require redrawing every district in the state.
Yeah, and Rob, do you mind just sort of explaining the little bit of the mechanics of how this bench trial before a 3-judge panel worked? I mean, it's sort of my understanding that this is a little unique, and you really just sort of rely on witness opinion, witness testimony before the judges. I mean, is that sort of the meat of kind of how you argue your points here?
Yeah, it's a very unusual situation. Normally you go and you file a case in federal district court, and it's heard by one judge. Then you appeal to the Federal Court of Appeals. In our case, in this area of the country, the Fifth Circuit Court of Appeals. And if you lose there, you can ask the U.S. Supreme Court to take the case. Here, because there's a federal statute that says that if you challenge the constitutionality of a statewide redistricting plan, which would only be a plan for the legislature, a plan for any other offices that are elected on a statewide basis, or the United States Congress. If you file a redistricting plan involving one of those and challenging the constitutionality of the plan, you get a 3-judge federal district court, and the appeal goes directly to the U.S. Supreme Court. You don't go to the Court of Appeals. The 3-judge federal district court is composed of 1 federal Court of Appeals judge from the state involved here, Mississippi, and 2 federal district court judges. And in our case, the Court of Appeals judge on the panel is Leslie Southwick. The 2 federal district court judges are Dan Jordan and Sewell Ozerden. He's from the coast. Judge Oserton's from the coast. Judge Sheridan is from Jackson. And so we presented our case to those three judges. It's not a jury. It's based on evidence, some statistical evidence about voting patterns, some demographic evidence about where the Black voters are concentrated, and then map makers who show how districts could have been drawn but weren't. And then we had a series of lay witnesses from these different areas, Black voters from around the state, who talked about the particular areas, talked about their experience, in some cases talked about the history of discrimination in Mississippi, cases talked about the present day reality in Mississippi. And our case was based on all of that. So several expert witnesses, some lay witnesses, and then the defendants put on, I believe 2 expert witnesses and 1 witness from the Secretary of State's office.
Yeah, of course, I was going to say the state is defending the existing plan.
Yeah, the state is. I mean, we sued the Mississippi State Board of Election Commissioners, which is the governor, the Secretary of State, and the Attorney General. And we, the Mississippi Republican Party intervened in defense of the existing plan. So those were the parties who were involved.
Yeah, refresh our memory. The makeup of the existing districts now. I mean, there's 52 Senate districts, and how many of those are Black majority now?
15.
15. So if y'all prevailed, that'd be 19. And then what about 122 House districts and
42 are majority Black. If we prevailed, it would be 45.
And
now it's possible that the judges might agree with us on some districts and not others.
Yeah.
They say, okay, instead of 4 majority Black districts, we believe 2 new ones should be drawn.
Yeah, and
so
when do you think that the 3-judge panel will issue a ruling?
It will be not in the next couple of weeks because we have to file post-trial briefs, but I would say in a few weeks after that. I mean, I can't say for sure. I would say 4 to 6 weeks if I were guessing about it.
Yeah. And these redistricting cases seem like every one of them is done differently in some way. You were successful, surprised a lot of people a few years ago in obtaining an additional Black majority district in the state Senate, and that was District 22, which is kind of on the lower delta into the part of Madison area. And was that similar to this case?
In some sense, I mean, it's interesting to look at these cases as part of a long history because when Black people finally started being able to vote in significant numbers after sort of the heroic struggles of the 1950s and early 60s by Black people in Mississippi and other places. The Voting Rights Act of 1965 was finally passed. Then people could vote in significant numbers. But there was not a Black member of the Mississippi legislature between Reconstruction, the late 1800s, and 1967, when one Black person was elected to the legislature of the 174 members, Robert Clark from Holmes County. It was another 8 years before any other Black members of the legislature were elected in 1975, when it was Fred Banks and Doug Anderson and Horace Buckley were elected to the Mississippi House. So that gives you 4. I mean, and litigation was ongoing since 1965 to get a fair drawing of legislative districts. So 3 more. Then in 1978 and 1979, the first Black members of the Mississippi Senate were elected, and 2 were elected. And then there was a total, I believe, at that point of 15 Black House members. So you're still grossly underrepresented. Then another lawsuit was filed in the early 90s after the 1990 census. That led to a number of additional majority.
Yeah, I like to think that was a big case. Yeah.
Yeah. Still Black people were underrepresented in the state. We filed that case you're referring to a few years ago, the Mississippi Center for Justice and the Lawyers Committee for Civil Rights Under Law, regarding that particular House District 22.
Senate District.
Yeah, Senate District. You're right. In the sort of Yazoo, Bolivar area, and the state had drawn it so that went down and picked up a lot of white population in Madison County, and so it was It was approximately a 50% district, but it was heavily a white candidate always won it, and that case led to the changing of that district to make it a clear majority black district. So that allowed another black member of the legislature. But black people are still underrepresented. We're still not at parity. And you look at the population growth. There was population growth between 2010 and 2010 in the black population, and then significant growth from 2010 to 2020. Of the black population in Mississippi. The white population went down, the black population went up, but there was no change in the number of black majority districts in the legislature between 2010 and 2020, except for the one that got changed as a result of our lawsuit. So now we're back in court again, along with this team of lawyers from several organizations. It's been a very cooperative effort. We put together a lot of evidence in the case. But we're now saying, there's still underrepresentation, and moreover, the plan is not keeping pace with the growth of the black population in Mississippi, and the Voting Rights Act requires more, in our view.
Yeah, and before we move on, I'd be remiss. One of your partners on this case is Carol Rhodes, who was involved in a lot of those cases that you cited going back. Is kind of was a forerunner on a lot of these issues.
Yeah. Carol is a longtime voting rights lawyer in Mississippi, and he was heavily involved in the case after the 1990 census. And
moving another case you're involved in at this very moment that I thought we'd just talk about for a minute was the school funding case, whether public money can be spent on private schools. That case was you and your partner, Will partner on this case. Y'all have worked for different organizations, but you and Will Barksdale argued this case before the state Supreme Court. Just talk a little bit about this case.
And as Will Bardwell from Democracy Forward, who's a longtime lawyer in Mississippi and a Mississippi native, as am I. And then we were also joined by Josh Tom of the ACLU of Mississippi in that case. And the thing is, if you're sort of a civil rights lawyer, there are a number of things to get involved in the state, and a number of statutes to challenge when the legislature, after the legislature finishes its sessions. And this one was in 2022. The legislature appropriated $10 million to private schools for infrastructure. But there's a little, the Mississippi Constitution of 1890 has many really awful provisions, most that were designed to restrict the vote to white people and to prevent the recently enfranchised and recently freed slaves and black people and other black people, but mostly slaves, from voting. They were allowed to vote during the Reconstruction period and elected a number of black elected officials statewide and otherwise. But then with the 1890 Constitution, sort of the Klan and the people who had come into power and wanted to restore white supremacy successfully did that by robbing black people of the right to vote. But there was one there were a few good provisions in there, and one of them is Section 208 of the Mississippi Constitution, which states that nor shall any funds be appropriated toward the support of any sectarian school or to any school that at the time of receiving such appropriation is not conducted as a free school. And a free school, as that term was used in 1890, means a public school, a school you can go to for free.
Yeah, it seems pretty clear.
It's very clear. Yet the legislature passed this $10 million appropriation. So we decided to challenge it. We represented Parents for Public Schools, which is just a wonderful organization of parents and teachers and others who support the public schools. And we won the case. We filed it in Hinds County Chancery Court. We won there. The Hinds County Chancery Court ordered the state not to distribute that money, held that the statute was unconstitutional, and the state appealed, and we had the argument last month. And we don't have a decision yet, but we'll see how the Mississippi Supreme Court rules on it.
Yeah, Rob, one thing about the case that sort of interests me, and something that a lot of people have brought up to me in my conversations with them about the case, is the legal issue of standing, and that it could be possible that the Supreme Court may not necessarily rule on the constitutionality issue, and it may come down to standing, and whether whether these parents and these teachers had enough of a legal standard to say that they were harmed or impacted enough by this legislation to bring forward a lawsuit. Do you mind just sort of talking through that issue, and why, from your perspective, you probably do believe that there was sufficient grounds to have standing?
Sure. An organization like Parents for Public Schools has what's called standing, which means you legally can come into court and have a valid basis to raise an issue about the constitutionality of the statute. So an organization has standing if its members would have standing if they had sued individually. And here we've got our primary argument for standing is based on the parents who are members of Parents for Public Schools. And there's sort of two areas of standing recognized in Mississippi law that come into play here. One is that taxpayers in many situations have standing to challenge unconstitutional expenditures of public money. The second is that parents of public school children have standing to challenge unconstitutional expenditures relating to the public schools. And so we have those combined in this case. And we have argued that Parents for Public Schools members include tax-paying parents of public school children. Now, what the state of Mississippi has argued, in arguing that we shouldn't even be allowed to be in court, is that this $10 million, which came from federal funds that were later deposited in the state treasury, would not necessarily have gone to the public schools if this legislation had never been passed. That it might have gone to something else. Because it wasn't money that was earmarked for public schools and taken away from the public schools. It was federal money that the state decided to put into infrastructure for private schools. Therefore, they say, because the $10 million wouldn't have necessarily gone to public schools, how can public school parents complain? And, our response to that is, Section 208 expresses a principle that no public money shall go to private schools. Therefore, any money that is going to be spent by the state on education should go to public schools. And that's just a hard and fast principle that needs to be followed. And anytime you give money to the private schools, even if you say, well, we wouldn't have necessarily given to that public schools, you are breaching that principle. And that principle protects public schools, public school parents, public school employees. And that is enough for us to have standing. It might have gone to public schools. Let's say they hadn't spent it on the private schools. It might have gone to public schools. If not, it would have gone to some other legitimate public purpose. And that these tax-paying parents have a right to complain about it. And what's remarkable about this, and this came out during the argument in Mississippi Supreme Court when the Attorney General's office said, it may be that nobody has standing. Because we pointed that out. If the parents don't have standing, who does? And the notion that the legislature could get away with funding the entire private school system if they wanted to, just giving $1 billion in private schools because nobody has a right to challenge it, even though it's pretty clearly unconstitutional, at least in our view. That's just astounding. And I think the courts, the courts are there to enforce the law and enforce the Constitution. And I think it would be quite remarkable if they were to say, in effect, if they were to rule against us, because that would, in effect, would mean, nobody can challenge it. Legislature can do whatever they want, no matter what the Constitution says. And I think that would be really a terrible outcome.
And Section 208 of the Mississippi Constitution is, we're kind of unique. The language in the Mississippi Constitution, I think, is more precise and clear than language in any other constitution, state constitution in the nation, except maybe North Carolina. There's some language in a lot of constitutions dealing with sectarian schools, but not, they don't address just free public schools in general like the Mississippi Constitution does.
Right. And if you look at actually South Carolina has it's very similar, and there was a case from the South Carolina Supreme Court that came out the same way we are saying this case ought to come out because they have a similar provision. But you're right, it's not every state that has it. And there's a particular history behind this. And in 1890, when they were writing the 1890 Constitution, there was a prevalent practice of public funds being used for private schools, including private religious schools, not exclusively. There's some private non-religious schools, but the public money was just being taken here and there, and it was a very prevalent practice. And the framers decided that is not right. If we're going to pay, if people want to pay for private schools, they can do so. But we've got to support the public schools with all the money we have, and therefore they wrote Section 208 in the Constitution. And this is true up to the present day, as you guys know. The Mississippi Adequate Education Funding Program has only been fully funded in 2 of the last 23 years. Our public schools are in dire straits in many parts of the state, and the notion that you're going to take, even if it's only 10 million. You may remember the old Senator Everett Dirksen from Illinois said, he says $1 billion here, $1 billion there, and pretty soon you're talking about real money. Even if 10 million may be a drop in the bucket as far as the state's budget goes, but that 10 million could be used, to buy toilet paper in restrooms.
Pay for a lot of teachers.
Yeah, it could be used to pay teachers. It could be used for more, for more school supplies. Some of these schools are in really difficult circumstances. And so now it's more important than ever with this funding crisis to make sure you hold the line on provisions like Section 208 that are designed to protect the public schools.
And we don't know when this case will be decided. The process on this particular case has moved pretty slow so far. So it just could be it could be months before it's decided.
Yeah, and I don't know that it's any slower than any other case. The justices take their time and they review it and draft opinions, and there may be 2 or 3 different opinions circulating. They all review it. They all give it a very thorough look. So we'll see. It could come down any day. It could come down in a few weeks. It could come down in a few months. I do expect it sometime this year, sometime within the next few months. But yeah, we don't know when it'll be.
Taylor, I'm gonna surprise Rob. Put him on the spot. I'm gonna ask him to get a little personal for a second. You've been a long time attorney in this state. You Millsaps graduate. You went to Harvard Law School. You could have done a lot of things coming as you began your law career. What made you? And you've carved out, I'm sure, a comfortable life for yourself. But you could have gone anywhere and done a lot of things. What made you decide to pursue this course of the law?
Actually, I don't know how much time you got. I'm gonna try to tell this really quickly. When I was about,
we're on the internet. We have infinity.
Okay, that's true. Yeah. Well, I won't make it too long. When I was about 12 years old, I grew up in Hattiesburg, in sort of an upper class family, white family, and there was a lot going on in the civil rights movement when I was 12 years old in 1967.
Especially in
68.
Hattiesburg.
Particularly in Hattiesburg. But I was a little sheltered from it. I didn't know that much about it. I had a little sense, but not much, about the civil rights movement. And I was reading, I'd sort of gotten to the point where I was old enough to read the newspaper, and I was reading an article about the trial of some Klansmen who killed Vernon Dahmer, the great civil rights and voting rights leader in Hattiesburg. And it was remarkable that the Klansmen were being prosecuted in the late 60s, because that sort of, a lot of Klansmen weren't even being arrested in those days. But they were prosecuted, and I was reading the article. And I was reading, and when reading it and reading about the trial, and there were two things that I was curious about. One was, what are the lawyers doing? They talked about the lawyers, the defense lawyers, the prosecutors, and I was like, what is a courtroom? What is this sort of drama that's being played out in this theater, for lack of a better phrase or analogy? And the other one was, why did they kill this man? And I started, and I went out and I read. I remember going to the school library, and this was some point after that, but I had this curiosity. I found a biography of Dr. King, Dr. Martin Luther King Jr., and I read about that, and that really opened my eyes to what was going on in the South, in Mississippi, in my own hometown. And I got very interested in civil rights. Meantime, I was also interested in the law. And I would sometimes go down, when a teenager, and go down to the courthouse. And if there was a trial going on, I would watch it. And I just got very interested in both things. And so I sort of figured around that time, that's when I started thinking about law and law school. And then I went to law school. And I always had an interest in civil rights law. Now, I do a lot of other things too. I do criminal defense. I do some civil stuff. I've been very lucky because I've got a variety of very interesting cases and interesting topics. And I'm a bit of a dilettante in that respect. But civil rights has been, just a major part of my practice. And that was just because of the belief that, the racial discrimination was wrong, and that there are many ways in which people's constitutional rights are being violated, and many of them in race cases, sometimes in other types of cases. But I've just found that very interesting and something I care about. And so I just decided to craft this sort of practice that I have. Many of the cases I'm doing are now with the Mississippi Center for Justice. I still also have a bit of a private practice as well. But yeah, it's all sort of worked out, and I've been able to get have my fingers in a lot of pies and be involved in a lot of interesting cases.
Yeah, and I mean, and as you say, you do a lot of a wide variety of cases, but the cases that aren't race-related cases, there a lot of times they still involve actions by the government that might be viewed as being detrimental to the little guy, for lack of better words.
Yeah. Bobby, I always joke that if I'm writing a story about litigation involving state government, there's about a 90% chance that it either involves Rob McDuff or another attorney at the Mississippi Center for Justice, Paloma Wu. And I remember, in which we don't have to get into a huge discussion about this, but there was litigation over Hinds County polling precincts on election day, and that was
what a mess.
It was a mess and just mass chaos. And I remember reading these legal briefs, and I got to the end, and I said, "Who is the attorney on this?" And sure enough, it was Rob McDuff, and then another one involved Paloma Wu, and so it's just always funny. And I always appreciate y'all for working with the media and being very responsive to a lot of our requests.
Yeah, and speaking of media, I guess we learned today, Taylor, that the Hattiesburg American is responsible for
For Rob McDuff.
For Rob.
That's right.
Pursuing the path he pursued. Maybe he wasn't reading the Hattiesburg American.
That's true. It was the Hattiesburg American.
Yeah.
Yeah.
That's for sure. Well, Paloma's a terrific lawyer, and I'm really, really fortunate to be able to work with her through her involvement with MCJ. And so, it's a small state,
Yes.
and there's a few of us doing this sort of stuff, but it's great to be able to be involved in some of those cases.
Well, thank you, sir, for doing this with us. We learned some stuff and we enjoyed it too.
Well, thank you. I really appreciate the work you two in particular, and Mississippi Today in general, and thanks for having me.
Thanks, Rob.
Thank you.
As we cover the biggest political stories in the state, you don't want to miss an episode of The Other Side. We'll bring you more reporting from every corner of the state, sharing the voices of Mississippians and how they are impacted by the news. So what do we need from you, the listener? We need your feedback and support. If you listen to the podcast on a player like iTunes or Stitcher, please subscribe to the show and leave us a review. We also have an email in which you can share your feedback. That address is podcast@mississipitoday.org. Y'all can also reach out to me or any of my colleagues through social media or email. And as always, thank you for your feedback and support. Subscribe to our weekly podcast on your favorite podcast app or stream episodes online at mississipitoday.org/theotherside. For the Mississippi Today team, I'm Adam Ganeshow. The Other Side is produced by Mississippi Today and engineered by Blue Sky Studios. We hope you'll join us for our next episode.